Hello friends. Today we are going to discuss about an important legislation called as Protection of Children from Sexual Offences Act 2012, also called as POCSO Act 2012, amended in 2019. I am Dr. Suresh Badadmat, Professor of Psychiatry, working at NIMANS, Bangalore. Before I start my presentation, I would like to place this disclaimer. This presentation is for academic and training purpose only. For legal opinion, please do contact an advocate. Conflict of interest? None. In this video, I'm going to discuss about the Protection of Children from Sexual Offence Act. What is this act? Why this legislation was required in India? What are the silent futures? And also critically reviewing this act and concluding how this legislation to be implemented. This video is targeted to doctors, psychiatrists, pediatricians, gynecologists, doctors working in emergency, mental health professionals, mental health review board members, JJ board members, child welfare committees, NGOs, advocates, judicial officers, and persons with mental illness and their family members. Let's discuss about child sexual abuse first. Child sexual abuse, as defined by World Health Organization, it clearly says it is a coercive act with a child who is unable to comprehend or provide consent, leading to serious physical or psychological damage. That means the essence of child sexual abuse evolves around the coercion, and also when the child is unable to comprehend what is happening to them and the adult or any other person takes advantage of the child. Further, let's understand how frequent, what are the different types of child sexual abuse. Child sexual abuse includes sexual activities like inappropriate touching of private parts, indulging the child in touching the private parts of the perpetrators, molestation, sodomy, exhibition, pornography, and cybersexual acts. Actually, these are some of them have been named. But however, child sexual abuse is a complex and a wider phenomena. In this whole process, the advantage is taken by an adult with the child. If you look at the prevalence, in India, around 53% of Indian children reported experiencing different kinds of abuse, which includes being forced to see nude photography, assault, sexual assault basically, inappropriate touching, and sexual abuse. So it is very common. Further, if you look at other important studies, it also said that the prevalence of child sexual abuse ranged from 4% to 41% in studies conducted exclusively in young women below 18 years of age. However, boys also reported up to 4 to 57%. So, this is a systematic review done by Chaudhary. A very important study was conducted by Ministry of Women and Child Development in 2007. This study was carried out by Prayas, an NGO, UNICEF, and also Save the Children. The reports of this study was astonishing. This survey was carried out in 13 different states with a sample size of 12,447. And the report came out telling that 53% of our children have faced one or the other form of sexual abuse. That means 50% of our children are not safe. If you look at the context of population of children in India, it is 41% of our population are children. If you look at the complete population is 138 crore. In that, 41% means somewhere around 50 to 53 crore population. In that, 50% of them have been sexually abused. Look at the numbers. And if you look at the context of our children's population across the globe, 17% of the world's children are there in India. That means we have a huge obligation to protect our children. Let's look at the crime against children in India. Look at the bar chart. Every year, the crime against children are increasing. This is National Crime Records Bureau's report. In 2019, 1,48,185 children faced one or the other crime against them. If you look at the number of children missing, NCRB data in 2018 clearly said that 67,134 children were missing. A total of 73,138 children were reported missing in 2019. That means every year the number of children missing are increasing. And if you look at the number of POCSO Act registered in 2019 is 26,192. That means Protection of Children's from Sexual Offence Act 2012, under this legislation, 26,192 cases were registered. That means the number of reported cases were almost 26,000. It's really heartbreaking. If you look at the number of the accused were known to survivors were 24,672. That means most of the adults knew the survivor and they took advantage of the children and sexually abused them. And in 2,153, the accused was a family member. That means our children are not even safe at home. This is National Crime Records Bureau 2019 report. And if you look at the numbers of crime, as I mentioned earlier, it is 1,48,185 crime against children. And 65 to 80% of the crime against women and children are done by the person who knows them. That means the trust is broken by an adult. What was the need for the legislation? Why this POCSO Act was implemented in 2012? Was there any need? Let's discuss about that. Earlier laws, before 2012, the legal mechanism was not effective and protection of male children was not adequate. Earlier, the maximum was rape. That means if a female child sexually abused or raped, that means there was a law. But if a male child is sexually abused, the laws were ineffective. Only rape was punishable. That means again, a male person doing against a female child. What about if a female adult is abusing a child? That means again, the law was not effective and the female abusers were not penalized adequately. However, other sexual offenses like oral sex, sexual assault, and even inserting objects into the children, vagina, oral anus, were not punishable offense earlier. And also, non-contact sexual abuse such as sexual harassment, stalking, pornography were not addressed adequately in the earlier laws. There was no mechanism of protection of children, especially the survivors, during the trial proceedings. As you know, in the court of law, the advocates are insensitive and they do the character assassination of the child. And the child has to undergo a trauma again inside the court of law. There was no adequate protection, again, when during the process of trial. And further, there was penetrative, non-penetrative, non-contact offenses. Those kinds of sexual abuse were not addressed in the earlier law. If it was done single times or multiple times, whether it should be punished as a single offense or multiple offense, such things were not addressed in the earlier law. If there was a one offender or a multiple offenders, is it equal or different? That was not addressed. If it was done on a healthy child versus a disabled child, it should be counted as equal, or else a stringent punishment be given or not was not discussed. Hence, a new legislation was passed. That legislation was called as Protection of Children from Sexual Offence Act of 2012. And it was amended again recently in 2019. India is a signatory for Child Rights Convention. That means we have an obligation to protect our children in the United Nations Convention. as well as even the Constitution of India gives power for the states to protect children and women. And under this, both the International Convention and also under the Constitution of India, this legislation was passed on 28th June 2012 and was again amended on 6th August 2019. Let's understand about this POCSO Act 2012. In this legislation, it clearly defines child means any person below the age of 18 years. That means it is the physical age, not the mental age. And even the Supreme Court was categorically said that it is the physical age which matters, not the mental age. That means physical age of any person below the age of 18 years will be considered as child. This legislation is gender neutral. That means any sexual abuse against either the male child or female child will be considered stringently under the POCSO Act. That means all children are brought under the ambit of this legislation for protection. Even the consensual sexual act with the child, either by any person, is considered as illegal because the child below the age of 18 years, the law presumes they're not in a position to understand, they're not in a position to know what is going to happen, and the adult may take the advantage or coercion. Hence, any kind of sexual activity between any person and a child is considered illegal. Let's understand the preamble of this legislation. The preamble of this POCSO Act clearly says an act to protect the children from the offenses of sexual assault, sexual harassment, and pornography, and provide for an establishment of special courts for trial of such offenses. So it's very clear to protect the children from sexual assault, sexual harassment, and pornography, and also to make special courts to run this trial. And in the process of during the trial, child's right to privacy and confidentiality be protected at every step, and also the best interest and welfare of the child as a matter of paramount to be considered during the process of litigation and also during the giving the judgment. So it's very essential the POCSO Act was implemented. And also all measures need to be taken to prevent the inducement or coercion of the child for engaging in unlawful sexual activity. That means the child cannot be used for sexual activity under any circumstances, either by coercion or even taking consent from the child. Exploitative use of children in prostitution or another unlawful sexual practices are completely illegal and punishable. And also, exploitative use of children in pornographic performance and using them as a commodity for various purposes in pornography is completely banned and punishable offense. Whereas sexual exploitation and sexual abuse of children are heinous crime and need to be effectively dealt and addressed by the state. Now let's understand the POCSO Act, how it has been divided. It has 9 chapters and 46 sections. The 9th chapter starts with preliminary, basically the definitions, and the 2nd chapter talks about sexual offenses against children. The 3rd one talks about using children for pornographic purposes and punishment thereof. Chapter 4 discusses about the abetment of and attempt of to commit an offense of against a child. Chapter 5 discusses about procedure for reporting of child sexual abuse cases. Chapter 6 discusses about procedure for recording the statement of the child. And Chapter 7 talks about special courts. Chapter 8 discusses about the procedures and powers of special courts and recording of evidence. And Chapter 9 is miscellaneous. Let's discuss the salient points of each of these chapters. As for the POCSO Act of 2012, there are 6 important sexual offenses have been classified. They are called as penetrative sexual assault, aggravated penetrative sexual assault, aggravated sexual assault, sexual harassment, and using a child for pornographic purposes. Let's discuss each one of them. Let's understand the penetrative sexual assault, that is discussed under Section 3 of the POCSO Act. Here, The penetrative means the penetration of child's vagina, urethra, anus, or mouth by penis or finger or object or any other body parts. That means this legislation is comprehensive and it is very inclusive in nature. It did not leave any kind of sexual assault on a child. That means it can be done by a penis or by a finger or by an object or any other body parts. And if it is done on a child, it is considered as penetrative sexual assault. Even the oral sex, either by a male or a female on a child, is a aggravated sexual assault. Or else, if the person manipulates any part of the body of a child so as to cause penetration into the vagina, urethra, anus, or any body part of the child, or makes the child to do with him or any other person, is also considered as aggravated penetrative sexual assault. Or else, forces the child to do above with another person is also considered as penetrative sexual assault. And this can be with or without consent. That means even a consensual act with a child of above nature is considered as penetrative sexual assault. Now, let's understand what is sexual assault. Whoever with the sexual intent, it's very clear, sexual intent, touches the vagina, penis, anus, or breast of the child, or makes the child to touch the vagina, penis, or anus, or breast of such person or any other person, or does any other act with sexual intent which involves physical contact without penetration, is said to commit sexual assault. Here, the point is intent. Sexual intent is very essential. Let's understand about the sexual harassment. Any person with a sexual intent, again, the intention is very essential. With the child, the harassment revolves around uttering certain words, gesture, exhibiting objects or body parts, making the child to do above things, showing pornography, stalking the child, threatening the child to use media, either maybe fabricated media against the child, will be considered as sexual harassment. That has been defined in Section 11 of the POCSO Act. Now understand the child pornography, which is becoming very, very rampant in our country. This has been defined under Section 13 and it has been amended in Section 2019 also. Any visual depiction of sexually explicit conduct involving a child, which includes photograph, video, digital or computer generated image, indistinguishable from an actual child, and image created, adapted or modified but appear to depict a child, will be considered as child pornography. That means it is not only having the child pornography, using it, transmitting it will be considered as an offense under this legislation. That means you cannot even use it for personal purpose. It is illegal. Child pornography is banned and it is illegal in India. Now let's understand the abatement and attempt to commit the crime. This has been defined under Section 16. Abatement, as per this legislation, clearly says that either instigating the child or else engaging with one or more people to conspire to commit an offense, or else intentionally aiding to commit the offense. So these are the three important definitions which has been given for the abatement or to commit a crime against the child. And it also includes people who traffic children for sexual purposes are also punishable under the provision relating to abatement in the Act. So that means even the offense has not been done, but they're abating or else attempt to commit a child sexual abuse is punishable offense under this legislation. There are stringent punishment has been awarded under the POCSO Act. The Act prescribes punishment in a graded fashion as per the gravity of the offenses. Punishment extends to imprisonment for life, which shall mean imprisonment for the remainder of the natural life of that person, may be liable to fine or even death penalty. That means the Constitution of India under this legislation POCSO, it has dealt the POCSO Act very seriously. Let's understand one more point. There is something called as aggravated offenses. Aggravated means it can be either the abused child is disabled. That means the child is already at the lower pedestal because of the less understanding. And if it is disabled, that means any person can take advantage of this child. Any such sexual offenses on that child will be considered as aggravated offense. Or else, when the abuse is committed by a person in a position of trust or authority vis-a-vis with the child, that means a person who is supposed to take care of the child has committed the offense. It may be a doctor, it may be a family member, police officer, teacher, warden, armed forces. Any person in the authority or else in the position of trust takes the advantage will be considered as aggravated offense. Even during the penetrative sexual assault, if the child becomes pregnant, or else the child contracts HIV, or else the child has grievous injury, is also considered as aggravated offenses. If it is a gang rape done by multiple people, done by multiple times, is also considered as aggravated offense. If the offense is committed on a child which is less than 12 years, is also considered as aggravated offense. So it can be aggravated penetrative sexual assault or else aggravated sexual abuse. So these are the two important to understand what is that aggravated offense. That means the crime may be same, but the person who has done it on which kind of child determines, and the number of people involved also determines the aggravated offenses. Now, understanding the 6 important sexual offenses named under the POCSO, as I mentioned: penetrative sexual assault, aggravated penetrative sexual assault, aggravated sexual assault, sexual harassment, using the child for the pornographic purposes. So these are the 6 important crimes have been clearly indicated under the POCSO Act. If you look at the sections, all odd sections, section 3 is for penetrative sexual assault, section 5 is for aggravated penetrative sexual assault, section 7 for a sexual assault, aggravated sexual assault for section 9, sexual harassment for section 11, and section 13 for using the child for pornographic purposes. So they are all odd numbers. If you look at the even numbers, S4, S6, S8, S10, S12, S14, respectively dictates the punishment. That means odd number defines the crime and even number dictates the punishment. If you look at the penetrative sexual assault, and this has been amended in 2019, the punishment is 10 years if the abused child is in 16 to 18 years. If it is less than 16 years, 20 years imprisonment. And if it is an aggravated penetrative sexual assault, it will be 20 years or death penalty. Sexual assault, 3 years. Aggravated sexual assault, 5 years. Sexual harassment, 3 years. Pornographic purposes, 3 years to 5 years. But however, remember this. This is pornographic purpose. And during the pornographic purpose, when they are shooting it, if a penetrative sexual assault is done, so that means that section also will be added. If it is aggravated penetrative sexual assault and the pornography is done, then the punishment will be 20 years or death penalty. So the pornography is dealt separately, and during the videography or photography, the act committed also will be considered for punishment. That has been amended in 2019. Now let's understand the child sexual abuse and mandatory reporting. This has been a very contentious issue recently. Under Section 19 of the POCSO Act, which clearly says any person, including children, who has an apprehension that an offense under this act is likely to be committed. That means there is a possibility an offense can be committed under this legislation, or has a knowledge that such an offense has been committed, and he shall provide such information to Special Juvenile Police Unit or to the police. So the mandatory reporting section 19 is very clear. If there is a possibility of an offense, or else the knowledge of an offense has been done, that needs to be reported to the police. However, in the same section 19, subsection 7 also gives protection for the person who informs. No person shall incur any liability, whether civil or criminal, for giving information in good faith for the protection of the child under the purpose of subsection 1. I will give an example. If a child is brought in front of a pediatrician and the pediatrician suspects there is a child sexual abuse because of certain symptoms, such as sexually transmitted disease is there in a child, or else child has trauma around the genital area, and now the pediatrician gives a complaint. It may be true or it may be false also, but the pediatrician is doing an act of good faith to protect the child. In during this process, if it is proved wrong, the pediatrician will not be liable whether for civil or criminal case. That's what it means. That means if you are a healthcare provider, if you are a teacher, or any person who are working for the best interest of the child, and you come to know that the child has been abused or there is a possibility of the child is going to be abused, you need to inform the police, and you need not worry about the civil liability or criminal liability, and no cases can be pressed against you. That means you have to act in good faith, not having a manipulative idea, or else you should not give complaint with some other intent. It should be for good faith to protect the child. But however, please understand, if it is just an apprehension and not sure if the child is telling true or false, even then, if you are apprehensive, you have a doubt, please report to the police, because this law is to protect the children. And also, as you know, the prevalence of sexual abuse in our country is 53%. That means every 2 children, if the pediatrician is seeing them on daily basis, one of them has been abused. That means 50% is a child sexual abuse. Even if there is a doubt, please report to the police. But however, remember this, the legislation makes it clear that the reporting obligation exists whether the information acquired through the discharge of professional duties or within a confidential relationship. That means you may be a doctor, you may be a teacher. During your duty, you have come to know about this, or else the child may come and say for a confidentiality, and you come to know. There is a mandatory reporting clause, section 19. And also, section 19 of the POCSO Act requires mandatory reporting of the cases of the child sexual abuse to the law enforcement authorities, and applies to everyone. It is not just doctors, it may be parents, it may be school teacher, or any person in the community. It is not specific to any profession. And failure to report a suspicion of a child abuse is also an offense under this act. And if somebody doesn't report, they will be charged under section 21. That is punishment for failure to report. Section 21, subsection 1 clearly says any person who fails to report the commission of an offense shall be punished with imprisonment of either a description which extends to 6 months or with fine, or both. That means if you do not report sexual abuse, 6 months imprisonment with fine or without fine, or both will be there. However, section 21(2) also says any person being in charge of any company or any institution who fails to report the commission of offense in respect to of a subordinate under his control also will be considered as a party to the crime and shall be punished with the imprisonment of a term which may extend to 1 year with fine. That means, please understand, if you are a principal of a school or a college, you come to know one of your teacher has abused a child, that is sexually abused a child, and if you do not report in spite of knowing that, along with the teacher, you will also be charged under the POCSO Act of section 21 subsection 2. Now, we were discussing about the mandatory reporting, but you need to be very sensitive about the reporting. Let's have a small exercise here. I apologize before doing this exercise because you need to know how difficult is reporting. So let's do a small exercise here. And I apologize before in hand. So now please take a pen and a paper and start writing. I, Mr. or Mrs. or a doctor, whoever you are, write your name. And you're writing a complaint letter. Please remember. And you're writing that you would like to bring to your kind attention of a police that my daughter, if you don't have a daughter or a son, your niece or a child whom you love have been sexually abused. Imagine, did you able to complete this letter? Did you write the child's name? For a hypothetical situation, many of these people, many of you do not write the child's name. I do this exercise to police when I am training them. Majority of the police do not write their child's name. Even in a hypothetical situation, a police cannot write. Imagine the parents who have undergoing when their child has been abused, sexually abused. Think about their mental status. Hence, you have to be very sensitive when you're reporting to the police because the parents are in a devastated stage. And at the same time, child is in a severe trauma. You have to be very careful the way you report to the police. Hence, reporting depends upon various factors. Although there is a mandate, but you need to take the child and the family into confidence and the reporting has to be done. So, the reporting depends upon various important factors such as when did the child sexual abuse occur? Was it 1 month back or recently? Whether there is a surgical emergency, the child needs to be treated immediately. Should I report now or later? Whether the safety of the child is there or not. If a father has abused or else a close relative is abusing the child, then you have to report immediately. Whether the child is a disabled child, there is a possibility it will be repeated many more times. At the same time, you need to know who is the offender. If the offender is a school teacher or a doctor or a warden who has access to the children, you need to act very fast. If the abuse has occurred around 2 months back and the child is stable and the family and the child does not want to give complaint, in such a scenario, you need to do counseling. You need to address the concern of the child and also the family members. It may take 2 or 3 sessions. After that, once you have taken the confidence of the child and the parents, take them together and report to the police. If you are in a hospital, you can register as a medical legal case. That means you have to stand with the child and the family members during reporting. At the same time, you need to provide support when the trial is going on. Hence, it is a process. It's not one event that you gave a complaint and your job finishes. No. Once you give a complaint or report to the police, your job starts then and there. You need to support the child. You need to support the family members. You need to facilitate because every citizen has a duty to protect the child. And you as a respectable person in the citizen in the society, you need to take an active step. Because sexual abuse is a lifetime verdict to the child and the child mental status and also to the family member. You being in a health professional or else in educational sector, you play an important role in providing support to the child and the family members. And you have a huge responsibility to play a role for a long duration. Now let's understand the procedure for media regarding the confidentiality. As you know, the media maybe mainstream media, it may be news channels, maybe social media. They are breaking the confidentiality. They report the child's name, photograph, whenever a child sexual abuse has occurred. Hence, to protect the confidentiality of the child, Section 23 is very clear. No reports in any media shall disclose the identity of the child, including the name, photograph, family details, school details, which section, male or a female child, from which neighborhood the child is coming. Any particulars of the child should not be disclosed in the media at any cost. If, in the interest of the child, it needs to be published, then the permission has to be sought from the judge. And the judge, after weighing the risk and benefit, then after the permission of the judge or the magistrate, it can be published. Further, Section 23 also clearly says the publisher or owner of the media or a studio or photographic facilities, if they come to know there are materials about the child sexual abuse has occurred, they need to report. If they don't report, and they are liable to be punished under this legislation. And they should make every effort not to publish or to release those photographs or videos of the child. Any contravention of breaking the confidentiality of the child will be punished up to 6 months, and which may extend up to 1 year with or without fine. That means this legislation has taken one step proactively to protect the confidentiality of the child and also privacy of the child. And the family should not worry, if I give a complaint, everybody will come to know. That needs to be protected. Hence, this law under Section 23 has clearly talked about right to confidentiality of the child. At the same time, there are special features. Under Section 27 of the POCSO Act, medical examination should be the prime, and the doctor who is examining the child should not wait for the FIR. If the child is bleeding, don't say it is a medical legal case. Wait for the FIR to occur, inform the police, inform the magistrate. If it is done, the doctor can be charged under Section 27. Don't wait for the legal procedure. You need to protect the life. That is Article 21, right to life and liberty should be upheld. At the same time, do not insist for an FIR. Treat the child first. At the same time, the legislation, Section 27 says that if the female child has been sexually abused, there is a need for a female doctor to examine the female child. That is very essential. And during the examination of the child, the parent should be there, or else a authority where the child has faith or a trust in them should be present when the examination of the child is done. This is very essential because the consent to be taken from the parents, and if possible even from the child also, before the examination is done. Now let's move the other important aspect of the POCSO Act. This is presumption of mens rea. That means presumption of offense has been committed. Under Section 29 of the POCSO Act, which is clearly says where a person is accused for committing or abetting or attempting to commit an offense, under this legislation, Section 3, 5, 7 and 9, the special court shall presume that such person has committed the offense, as the case may be unless the contrary is proved. That means the law says if the child says that Mr. X has committed the crime, the special court will say yes, it has been committed. And now the accused has to prove that he has not committed the crime. Means the burden of proof is on the accused, not on the prosecution. That means defense has to prove beyond doubt that he did not commit a crime or she did not commit a crime. That means the burden of proof is on the accused. Further, it also says presumption of culpable mental state. That means Section 30 clearly says, in any prosecution for an offense under the Act which requires culpable mental state on the part of the accused, the special court shall presume the existence of such mental state. Here, the culpable mental state means intention, motive, knowledge of a fact, and belief or reason to believe a fact has been done or a crime has been occurred. So, please understand, in this law, to protect the child, the accused has to prove that he has not committed the crime. The state will say, the child has said it has been abused. The accused has to prove that he has not committed the crime. And also, culpable mental status has been considered by the state. That means that person has that mental state. And the proving has to be done beyond reasonable doubt. And it has to be clearly said that the accused to prove beyond reasonable doubt that he had no such mental state with respect to the act charged as an offense in the prosecution. That means the accused has to prove beyond reasonable doubt. That means state wants to protect the children at any cost. Now, looking at the assistance by an expert. Many a time, children in the court of law may not be able to communicate. They may have speech difficulties. They may be deaf. They may not be able to speak. In such a scenario, Section 39 under this legislation clearly says, government shall prepare guidelines for use of governmental, non-governmental organization. That means NGOs, professionals and experts or person having special knowledge of psychology, social work, physical health, mental health and child development to be associated with the pre-trial and trial stage to assess the child. That means the court has been given full power to use the experts either in the pre-trial or during the trial stage. Now, let's understand how the POCSO Act has been child-friendly proceedings has been inculcated. Here, the child-friendly proceedings means special juvenile units. That means certain polices have to be trained under the POCSO Act and they need to go to the child's house to take the FIR. The child need not come to the police station. And the police who is going to visit the child's house should not be in uniform. And if possible, a female police officer at the rank of sub-inspector and inspector should be there. And special child-friendly courts need to be established. The special prosecutors who are trained in child psychology and also how to interview the child should be made available in the special court. And it should be non-adversarial procedure to be done. That means you cannot go and threaten the child during the proceedings. And it has to be in-camera proceedings. That means the people involved in the case should be there in the court. No other extra person is allowed inside the court. Inside the court. At the same time, accused should not be exposed to the survivor. That means the child at any circumstances should not see the face of the accused. That is very paramount because the accused may threaten the child also. And also, defense lawyer is not allowed to threaten the child, asking repeated questions, or else using the tone of questioning at higher manner should not be done. And the character assassination of the child is not allowed at any cost. Hence, both the lawyers have to questions to be framed and it has to be routed through the magistrate. That means magistrate will ask the question. Here, the magistrate also need to be trained in child psychology and how to interview the child. And also, there are important provisions of providing compensation to the child and the family. And here, the compensation is given for child's mental and physical trauma that needs to be paid by the accused, and the accused is not in a position to pay. That means the state has to take the responsibility of rehabilitation of the child, for providing treatment for physical trauma and also mental trauma. That compensation is very essential, which has been brought under the POCSO Act. Further, recording of the statement of the child by the magistrate under section 164 of the CRPC 1973 has been brought here. So that means if the child is admitted in the hospital, the magistrate can record the statement. And the recording of the statement should be done in child's own word. And further, the proceeding is time bound. Within 1 year, the case needs to be closed. That means the case needs to be decided. That is very essential. That means obligation is placed on the magistrate and also on the advocates. Now we have learnt about the POCSO Act. Let's discuss what are the good and the bad part of the POCSO Act. Let's critique it. In this, consensual sex between the adolescent or the children is a punishable offense under this legislation. Imagine 17-year-old male and a female, if they are involved in sexual activity, both are punishable. Both are survivors. At the same time, both are perpetrators. They are accused. And they will be charged under the JJ Act. At the same time, this law prohibits sex till the age of 18 years. At the same time, now if the mandatory reporting is there, that means if a teenage becomes pregnant, if she wants to do medical termination of pregnancy, she cannot go to the doctor because the doctor has been placed under the obligation of section 19 for mandatory reporting. And if she comes to the hospital for MTP, now the doctor is forced to report to the police, here I have a teenage who is pregnant. That means many of the teenage will not come to seek for medical termination of pregnancy. That means illegal abortion, non-medical abortions going to be increasing. At the same time, if you look at the POCSO Act of 2012, it is aspirational in nature, an amazing law, one of the best legislation across the world. But till date, implementation is very poor. If you look at the requirement of lady medical officer for examining the female children, it is very difficult. Imagine in a taluk or a tehsil, if a female child has been abused, now you have to find a lady medical officer to examine the child. If you don't have lady medical officer, that means now the child has to be taken to the district hospital to find a lady medical officer to examine the child. So this can be a challenge in certain areas of our country. At the same time, human resources are required, especially in the hospital, to support the family members and the child. Imagine we required psychologist, psychiatrist in every district hospital and taluk hospital whenever child sexual abuse survivor is brought and their family members are brought. That means we do not have adequate human resources to protect the child and the family members, to provide counseling, to provide information, and also to support them during the trial process. We talk about special courts. That means POCSO courts should be established in every district. That means it should be child friendly. But however, although the name looks very good, it is the same judge, same building, same advocates with the same old mindset. Just it is called as POCSO court or special courts. Unfortunate. We have not invested in a special courts, separate building, child-friendly environment, availability of toys, non-adversarial nature. Imagine the child has to go to the court complex, which will be buzzing with the advocates, which will be buzzing with the accused people running here and there. In such a scenario, how does a child will give information in the court of law? At the same time, training of all stakeholders, have we done? The training is very low. We have not trained the teachers, advocates, wardens, doctors, nurses, even the judiciary. The training has not occurred. Do we have enough of resources in the court of law? to adjudicate POCSO case in a child-sensitive manner. We do not have adequate resources. That's the biggest pitfall of this legislation. At the same time, this legislation did not talk about registry of the sexual offenders who have been punished under this legislation. Wish we are going to have a registry of these offenders available online so that we know this person has committed a child sexual abuse, whether this person should be allowed in the vicinity of the school, or else he should be given a job inside a school, or else in a hostel. So this registry should become mandate. At the same time, many people requested for chemical castration of the perpetrators. That means if a person is proved under the POCSO Act, he has committed a crime, whether chemical castration to be done so that this person is not going to abuse another child. At the same time, do we have excellent forensic science lab in every district? We do not have. Where do we collect the genetic material? How we are going to collect the evidence? How they will be examined? And we need to dispose the case within 1 year. Unfortunately, FSL labs are there, but they are not equipped completely. The another important point I would like to bring is care at one step. That means care at one stop, or else care under one roof. Imagine a child sexual abuse has occurred, and if the child is brought to the hospital, invariably the chief medical officer or a casualty medical officer will examine. He will refer the child to the pediatrician. The pediatrician will examine, and he will refer the child to maybe gynecologist, or else he may even refer the child to the dermatologist. That means 3 to 4 doctors have seen them now in a same building or maybe different buildings of the same hospital. At the same time, if a police is going to examine, a junior police will examine first or talk to the child. Next, the senior police officer will come. After that, a social worker who is going to protect the child will come and discuss again with the child and the family members. After that, advocates, judges. That means how many people is going to interact with the child and the family members. That means there is a possibility if all these people are not trained and they come and ask questions in an insensitive manner, that means re-traumatizing will occur. That means secondary victimization is a high possibility in such a scenario when all these people are not trained. Hence, there should be care at one stop should occur, or care under one roof should occur, where all trained personals are available and they know how to examine the child or a woman who are being abused. But however, if you want to have a child sexual abuse free community, means certainty of punishment and rule of law is to be ensured. Unfortunately, POCSO do not ensure the certainty of punishment and rule of law is not ensured here. To conclude, my dear friends, this legislation increases the scope of reporting of sexual crime against children. It expands the definition of sexual assault to include non-penetrative sexual assault, non-contact sexual assault, and also aggravated penetrative sexual assault. And it also brings in the mandatory reporting of sexual offences, mandatory making of special courts, in-camera trial, child-friendly environment. A parent or a trusted person should be there during the examination or else during the testifying in the court of law. And also to provide social welfare and well-being of the child victims, particularly when the abuse is a parent or a guardian of the child. At the same time, every effort should be made to avoid secondary victimization of the child during the trial process. And confidentiality is prime under this POCSO Act. Thank you very much for giving your valuable time. Stay safe and pledge to protect the child from sexual abuse.